welcome. It is my great pleasure to welcome you today to our third annual UBC Constitutional Lecture and to introduce our honorable lecturer, Justice Bradley Miller of the Court of Appeal for Ontario. The title of Justice Miller's talk today is Virtuous and Vicious Constitutional Interpretation. Justice Miller was appointed to the Superior Court of Justice in Ontario in January 2015 and was elevated to the Court of Appeal for Ontario in June 2015. He holds a DPhil from the University of Oxford, where he wrote his dissertation under the supervision of the renowned legal philosopher John Finnis. He also holds an LLM from the University of Edinburgh and a Bachelor of Commerce and a Bachelor of Laws from the University of British Columbia. He may sit on the Court of Appeal for Ontario, but he is one of us. He is a Westerner, and he grew up in Vancouver, and his family has deep roots in the Okanagan Valley, hailing back to the 1890s. Before becoming a professor or judge, he practiced commercial and constitutional litigation in Canada with Lerners LLP and Miller Thomson LLP in Toronto. From 2005 to 2015, when he was appointed, he was a law professor at the University of Western Ontario, and his published work includes collections such as The Challenge of Originalism, 2011, Proportionality and the Rule of Law, 2014, as well as the co-authored monograph Legislated Rights, published in 2018. His academic work questions many of the common assumptions in Canadian constitutional jurisprudence. If you take a course with me here, especially the advanced constitutional law course, so a course on rights and civil liberties, you will read some of his academic writings with me. An example of his willingness to question some fundamental assumptions include his essays on constitutional interpretation, which have shown that the case that is often used as a touchstone for a living tree or living constitutionalist approach to constitutional interpretation, Edwards in Canada, or more often known as the person's case, is actually a case that looks to the original public meaning of the word person rather than simply updating it in accordance with the moral preferences of the judges that sat on the Judicial Committee of the Privy Council at the time. But now I'm already getting too far into the topic that you came to hear Justice Miller speak about, so I'll stop there for that. His academic work has translated into an already formidable jurisprudential record on the Court of Appeal for Ontario. He has made significant contributions to the law of freedom of expression, freedom of religion, and equality rights. His contributions to constitutional methodology, particularly his approach to limiting charter rights and his critique of charter values language and unwritten constitutional principles, have been cited by courts across Canada, including the Supreme Court of Canada, the only court sitting above him. He is one of the most important jurists in our country, and we are lucky to host him and recognize his accomplishments here in his home province at his alma mater. So please join me in welcoming Justice Miller.
Well, thank you very much for that very generous introduction, and I particularly thank Professor Siglet and Professor Irving for the invitation to come here. It is very special for me to be back in the Okanagan Valley. It's a place that's very, very special to me, and to be back at the institution of University of British Columbia, where of course I spent so many years as a student. I did see some of the promotional literature here, something about wit and wisdom. I think they might have oversold the lecture a bit. There are many things that are possible in a lecture on constitutional interpretation. Mirth is not one of them, but here we are. So faith in the integrity of constitutional courts requires confidence that judges are following a discernible rule-based methodology and not merely making things up on the fly. One of the harshest criticisms that can be leveled against a judge is to impugn the bona fides of that judge's reasoning and to make the accusation that a judgment isn't simply wrong, but results-driven, not legally directed, purely a manifestation of will. The criticism is often made in the context of constitutional adjudication, particularly in those cases that decide the scope of charter rights. And because charter rights are so obviously the product of moral judgments about better and worse ways of how to live together and what it means to respect the dignity of persons, moral reasoning is never far from the surface of charter cases. And this interconnection of legal and moral reasoning in constitutional adjudication naturally raises the question of what it is that judges are doing when they answer constitutional questions. People want some assurance that judges are faithfully applying the rules set out in advance by others. That is, deciding cases according to law and not according to personal convictions about what might seem best to them. The concern is understandable. Judges, after all, have considerable technical proficiency with law and legal reasoning, but taken as a group, they have no particular expertise or education or comparative advantage over any other group when it comes to non-technical moral judgments. So there might be some discomfort about giving their moral judgments the force of law. It might seem uncontroversial that to maintain judicial legitimacy, we need judges to stick to the law and avoid moral reasoning. Judicial virtue, on this view, lies in the disposition to just follow the law, call balls and strikes. And judicial vice would be the disposition to set the law to one side and impose one's moral judgments instead. Now, there's a grain of insight here, but the claim is exaggerated and draws the line between virtue and vice in constitutional interpretation in the wrong place. Over the course of this lecture, I'm going to argue that constitutional interpretation, a great deal of the time at least, cannot dispense with moral reasoning. And if, as I hope to persuade you, moral reasoning is not only unavoidable in much judicial reasoning, but also necessary, then the question of legitimacy, of what it is that judges should be doing, must be subtly recast. The question is not how to eliminate moral reasoning, but how practical reasoning, and especially moral reasoning, is to be appropriately directed and constrained. In constitutional law, this question, or set of questions, often erupts as a proxy battle between living constitutionalists and originalists. For the time being, let's say that living constitutionalists are those who believe that the Constitution must be changed and adapted by judges, and originalists are those who deny this. Now, this is a gross and misleading caricature, but we'll fix that later. The problem of legally constrained practical reasoning presents in many other adjudicative moments as well. And in the time we have today, I want to explore with you three hotspots in Canadian constitutional law where the place of moral reasoning is either contested or should be contested. First, as I mentioned earlier, the originalism, living constitutionalism debate. Second is the doctrine of proportionality, which is used in Canada to determine whether the limitation of a charter right is justified. And the third is what we call appeals to charter values. The first of these, the originalism living tree, is a contest of how to restrain judicial subjectivity at the level of constitutional interpretation. Proportionality analysis, the second, tends to define rights broadly and largely abandons questions of interpretation, focusing instead on questions of justification. And appeals to charter values, which pop up all over the place in public and private law, is a strategy for prioritizing the principles that underlie the Charter of Rights and Freedoms over other competing moralities. But first, a quick digression. For the benefit of the political scientists in the room, which is more or less all of you, I think, let me immediately confess that judges are not, of course, the only interpreters of the Constitution. They're not even the most important ones. Wherever there is governmental action, there has been constitutional interpretation. Most obviously, in the creation of a statute, whenever a bill is drafted, introduced to Parliament, debated, voted on, proclaimed into force, there is, at least in the background, constitutional interpretation. All of these acts proceed on the basis of some understanding that this act of lawmaking is within the jurisdiction of the government proposing it, and it does not violate any provision of the Constitution. And anyone with standing can challenge that conclusion before a court, and the court may conclude that Parliament was wrong. And under our Constitution, the government may, in turn, conclude that the court was wrong. And in some cases, we'll have the option of reenacting the legislation using the notwithstanding clause. The point is that the government's obligation to interpret the Constitution and to be guided by it in its acts of lawmaking is a primary obligation and not a delegation from the courts or derived in any way from judicial power. Judges enter the picture, if at all, only secondarily, after another institution with the authority and obligation to interpret the Constitution for its purposes has already done so. So while we're focusing today on the specific function of courts in interpreting the Constitution, I don't want to be misunderstood as suggesting that courts enjoy any sort of monopoly on constitutional interpretation. Far from it. But I am a judge, and what insights I have are related specifically to judicial reasoning and how courts are to approach constitutional questions. So I'm going to focus on what it means for judges to interpret the Constitution virtuously and faithfully. So then, let's turn to what judges do when they are interpreting the Constitution. What is virtuous constitutional interpretation? A simple answer would be that virtuous interpretation of the Constitution is a matter of reading the constitutional text for the purpose of understanding the constitutional settlement that the text memorializes and giving it legal effect. It proceeds from the understanding that the constitutional text was deliberately chosen from among alternative formulations and was intended to guide resolution to some, but not necessarily all, constitutional questions. It recognizes that the scope of the text and the settlement is finite. The Constitution is necessarily silent on a great many things, but those matters that it purports to settle are to be treated as settled. It does not allow for amendment outside of the process it specifies. There are to be no new answers to settled questions, and judges must subordinate their own all things considered view of what might be best to what is actually settled by the terms of the Constitution. Now, to those who might be skeptical about the significance I'm placing on the text of the Constitution, I simply ask that you think back to the debates preceding the adoption of the Charter of Rights and Freedoms. People on this side of the room might remember them. I think people on this side not. What was the purpose? What do you suppose was the purpose of all the debates, all of the traveling consultations, all of the submissions from interested groups, the reference questions that were brought to the Supreme Court, the 3 reports commissioned by the Kershaw Committee of the UK House of Commons? Why was there so much debate about and refinement of specific language used in, for example, the anti-discrimination provision in Section 15? Why was the language of due process excluded from Section 7? Why was there so much back and forth on the specific wording of Section 1, the limitation clause? It's because those who held the drafter's pen understood that the words mattered. They had the responsibility to come to a sound agreement and to accurately convey what was actually agreed. And what was agreed, the constitutional settlement, was intended to provide an enduring and stable framework to guide collective action into the indefinite future. And so it is that the Supreme Court of Canada has in recent years repeatedly emphasized the place of the text in constitutional adjudication. To take just one example from more or less at random, we have the case of Quebec Attorney General versus Numbered Company from 2020, where the court said constitutional interpretation, being the interpretation of the text of the Constitution, must first and foremost have reference to and be constrained by that text. Indeed, while constitutional norms are deliberately expressed in general terms, the words used remain the most primal constraint on judicial review and form the outer bounds of purpose of inquiry. Respect for constitutional settlement requires that the constitutional interpretation be genuinely a matter of retrieval, of understanding some fact of the matter about what was settled and what was conveyed to us through the specific language that was chosen. But faithfully adjudicating according to what was settled is actually much more difficult than might first appear. Mistakes can be made, yes, and courts acknowledge as much on those rare occasions when they overturn past precedent, or openly overturn past precedent. But there is a more significant problem for the judges aiming for virtuous interpretation than making a simple mistake. It's the problem of getting the constitutional settlement right, but concluding that it doesn't actually give that much guidance, that there isn't much there. More on that in a minute. What of vicious interpretation? If virtuous interpretation requires self-abnegation, submerging oneself beneath what has been settled in advance by other institutions, the corresponding judicial vice is the inflation of the self, of discreetly and perhaps through impressive appearing technical artifice, seizing a power not granted in order to do justice according to one's own lights. The central case of a vicious interpretation would be a matter of setting the constitutional settlement aside and replacing it with something of one's own devising so as to better do justice as one perceives it. It would be to amend the Constitution in defiance of the very specific process that the Constitution provides to the very specific institutions entrusted with that function. Now, before anyone gets overexcited, this account of vicious interpretation I'm offering is nothing more than a theoretical straw man. It's just a conceptual sketch to serve as a foil for the concept of virtuous interpretation that I actually want to explore. I'm not suggesting that there are examples of judges reasoning in this way in the wild. So when we get to Q&A, do not ask me for examples. And please do not offer me any examples of your own, especially if any of my own cases are leaping to mind. If you must have a concrete hypothetical, the comparatively recent municipal election case from 2019, we'll take that one, City of Toronto versus Ontario. Apologize for the Toronto reference. I know it rankles a bit, but it's what we have to work with here. That case involved a charter challenge to an Ontario statute that reduced the number of Toronto City councillors from 47 to 25 shortly before the municipal election in 2018. Now, there were many arguments advanced in court as to why the legislation violated the Constitution. The argument that initially succeeded at trial before being overturned by my court and on further appeal to the Supreme Court of Canada was that the legislation limited the freedom of expression of the persons who were running for the office of city councillor and those who wanted to vote for them. A majority of the Court of Appeal for Ontario and a majority at the Supreme Court rejected the argument, as well as an argument grounded in unwritten constitutional principles. It was not a very good argument. But for an example of the type of vice I'm considering, I want you to imagine an argument that was not made before either court. And that is that the legislation violated Section 3 of the Charter, which provides that every Canadian citizen has a right to vote in an election for members of the House of Commons or of a legislative assembly. Now, on its face, Section 3 had no application to the City of Toronto case. Section 3 does not provide a charter right to vote in elections for city councillors. It only provides a right to vote in elections for members of federal and provincial assemblies. Now, for this hypothetical argument to succeed, it would have required a court to first hold that Section 3 applied to municipal elections. This would be asking a court to add something to the constitutional settlement that was deliberately and obviously left out, omitted. It was not part of the settlement. Now, the argument could have been run, and only to exaggerate slightly, well, in 1982, people didn't even have iPhones, and if the promise of the Charter is to be fulfilled and the Charter is to remain relevant to contemporary Canadians, Section 3 must be extended to municipal elections. A hypothetical judge who fell for that would be engaging in the vice of setting aside the actual settlement and reauthoring the Constitution. Now, vicious interpretation of this kind is not particularly interesting conceptually. Vice, as people on this side of the room probably know better, is effortless. But the practice of virtue is not easy. In the context of constitutional interpretation, the difficulty emerges when one walks through the various steps required to reason through a constitutional question and see how little clear guidance the law sometimes provides. Virtuous interpretation is interesting because of the sheer complexity of constitutional adjudication. But you might ask, why should virtuous interpretation be difficult? If it's just a matter of faithfully following the constitutional settlement, how hard can it be? Isn't a judge's role just to sit there, watch the pitch, and call balls and strikes? And that recalls to mind that time my eldest son, then in grade 9, came to the courthouse for one of those disillusion your children days. And his mother said to him afterwards, "Well, you got to see Daddy in action. How was it?" And he looked at her incredulously and said, "In action. He just sits there." Yes, we just sit there. But unfortunately, it's not as simple as calling balls and strikes. But to explain why, I need to walk through a few concepts that I think will better illuminate the nature of judicial reasoning. There's three of them. They are: one, the distinction between technical and moral reasoning; two, the concept of vagueness; and three, the distinction between constitutional interpretation and constitutional construction. Okay, so let's start off with moral reasoning and technical reasoning. The medieval theologian and philosopher Thomas Aquinas made many conceptual innovations that help us to better understand law and legal reasoning. And one of them is a distinction among the four orders of reality with which human reasoning is concerned: the natural, the logical, the moral, and the technical. And each order has its own rationale and its own sets of relations. And although each contains elements of the others, analyzing a phenomenon proper to one order with the tools of the other order will result in confusion. The natural order is easily grasped. This is the order of reality, physical and metaphysical. It's the world that we observe and we investigate, but we don't create. It's the natural. Logical, I mean logical in the widest sense of the word. It's a cogency of arguments, explanations. The third order is the order of practical reason, or equivalently morality, the order of dispositions and morally significant choices. It's the domain of ethics, of moral philosophy. It includes judgments about better and worse ways of living, of ascertaining duties and obligations. The fourth order, okay, so we've got natural, logical, moral. The fourth order is the technical, the realm of doing and making, the artifactual, the bringing order to things that are under our control. It includes the making of physical objects, maybe making wine, I suppose. I'm reaching for a local example. Or establishing intangible systems like the rule of law. It, of course, relies on the natural and the logical order for its inputs, but it has a form of reasoning that's nevertheless distinct from these. Now, these four orders intersect in many ways, and all of them can be relevant to adjudication. But what the legal philosopher John Finnis has called the elusiveness of legal reasoning lies in the fact that this fourth order object, the law, is constructed for the third order moral purpose of living together in a just order of fair and right relationships. So law is thus a cultural object or instrument that's been developed for the moral purpose. It's needed to coordinate the actions of members of society who we can't expect to agree all of the time about everything. Legal reasoning, I want to suggest, is predominantly technical reasoning. The great majority of legal questions are answered without any recourse to moral reasoning at all. These sorts of questions require an understanding of law and how it functions, how to identify the source of legal obligation, say common law and statutes, to know who and how they bind and how legal rules that interact with each other coexist, sometimes superseding others, sometimes modifying them. And examples of these dominantly technical sort of legal questions, I mean, they're really easy to hand. For example, what steps do you need to take to enter into a contract, or to make a will, or to start a lawsuit, or to defend one, to conduct a trial, to enter in an exhibit into evidence? How do you determine whether you're entitled to appeal a judgment? To what court? All of these questions have readily available right answers that can be discovered quite simply just using ordinary legal techniques. This isn't to say that answers are always straightforward. If you ask anybody about the distinction in my court between final and interlocutory rules, we'll be here all night. So the answers aren't always straightforward. Everybody doesn't always agree what they are, but every trained lawyer understands the methods for arriving at them and what counts as a source of obligation and what doesn't. And legal doctrines that we create can be especially helpful in directing judges to break down complex problems into discrete steps, to make sure that the judge doesn't overlook any relevant consideration or take into account any irrelevant considerations. Legal doctrine reduces complexity by taking many options off the table and giving judges analytical structures to work with. And of course, because law is in the service of human persons, there always remains some residual question about the law's justice, whether it is in fact serving the good it is meant to serve. Okay, but that's a question for another day. When we think of law in terms of the everyday legal questions I just rhymed off, we see the attraction of the umpire metaphor. A lot of law is just like reading up on the rules that establish a strike zone and then applying the facts to the rules. Much law is like this, but not all. And to understand why not all is like this, we need to consider the second concept I wanted to discuss with you, which is vagueness. Okay? So the umpire metaphor has a kernel of truth in it, but the metaphor is not particularly helpful in most difficult constitutional cases. Constitutional cases rarely turn on the simple application of a rule to a set of facts or the simple interpretation of a text. And this is because much of the language used in constitutional texts is deliberately underdeterminate, framed in concepts that lack precision and whose meaning is often contested. Take, for example, constitutional concepts like the principles of fundamental justice, or the right not to be secure from search and seizures, but specifically from unreasonable search and seizure, or the right not to be subjected to cruel and unusual punishment or treatment. A vague concept may have a settled core of meaning, but it also admits of borderline cases that may be difficult to classify. When laws, including constitutions, are drafted using vague or general terms, it limits how much guidance the law can give to judges, and it opens the door to idiosyncrasy. And idiosyncrasy is something that we want to minimize even if we can't avoid it entirely. Vagueness and generality in general make virtuous interpretation more difficult. Okay, we've considered the distinction then between technical and moral order, and we've considered vagueness. Let's look at one more set of concepts before we return to the problem of how to constrain moral reasoning. And this is the distinction between interpretation and construction. Now, interpretation, in the sense that I'm using it, has a narrow and technical meaning. It's a question of fact, an act of retrieval, of ascertaining the semantic meaning of words that were used in the constitutional texts. And this exercise presupposes that the meaning of the text is fixed at the time it was made. No amount of subsequent linguistic drift in the words or changes to how we use words can alter the meaning of the settlement that was locked in at the time of enactment. So to take for an example, and as the Privy Council held in the Edwards case, which Professor Siglet mentioned earlier, when we're considering the meaning of the word person in the Constitution Act of 1867, we're concerned with understanding what was meant by the drafters and ratifiers in 1867, not at some later date. This fixation thesis is superficially controversial in the Canadian Legal Academy, but I don't think it's actually controversial in constitutional practice. Many academics and judges will say they disagree that the semantic meaning is fixed in enactment, but I can think of vanishingly few instances of a judge actually denying it in practice. Now, interpretation is a necessary first step in legal reasoning, but it's not everything. In some instances, it doesn't do much work at all. And although understanding the text is always the first step, no one, whether judge or legislator, who is seeking to reason with a constitution can stop at the first step. The second step on the schema that I'm suggesting to you is construction. Construction is a matter of taking the text that's been interpreted, that is, the semantic meaning of it, and relating it to other legal propositions to create doctrinal rules that can be applied to particular disputes. That is, construction is a matter of taking meaning, which is a question of fact, and generating legal obligation from it. Let me give you an example from Section 1 of the Charter of Rights and Freedoms. The text of Section 1 provides the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Now, remember that interpretation is a matter of determining the limits of what has been settled by the words used in context. And the words used here are fairly general, though not entirely open-ended. What limits on rights can be justified by the fact what lives in a society? Well, first, we need some background understanding of what's meant by a society. And the text here gives some direction. This is the society that it's contemplating is a free society, a democratic one. And it's not a society that's been conjured out of nothing without a history. It's the specific society extending through time that produced this particular constitutional settlement over the course of making many other self-constituting acts over hundreds of years. So we have patterns of behavior and institutions emerging out of several hundred years of history from which to take some guidance. Early charter jurisprudence from the Supreme Court of Canada emphasized the charter's continuity with the past, such that the rights enumerated therein had to be, quote, placed in their proper linguistic, philosophic, and historical context, from the Big M Drug Mart case from 1985. So the settlement to which this particular text bears witness easily rules out limits and justifications that might be obtained in societies without free markets or with an attenuated commitment to respecting the dignity of all persons, or with limited regard for autonomy, privacy, or private property. Stated positively, the settlement includes the limits and justifications needed to preserve the type of society that generated the Charter in the first place. Okay. But interpretation of general terms will only go so far. After that, we enter the construction zone. And so it is that in the case of Oakes in 1989, the Supreme Court of Canada offered a doctrine or a legal test that it cobbled together from European Court of Human Rights jurisprudence for determining the circumstances in which a limit to a person's charter interests are justified. The Oakes test, which separates the question of whether a person's rights are limited from whether that limitation is justified, uses a proportionality test. It is a construction. It was not mandated by the language of Section 1. The court could well have developed some other doctrine to give effect to limits on rights. It could have, for example, concluded that reasonable limits are inherent in the nature of the rights themselves rather than being something external to rights. And the court could permissibly abandon the Oakes test in favor of some other doctrine and thus change constitutional law without having changed the constitutional text or the settlement behind it. So the Constitution, in that sense, can change. Construction is inevitable if one is to reason with a Constitution. Very few constitutional provisions are written with sufficient particularity that little or no construction is required. Wherever the text is interpreted and combined with judicial doctrine or applied to particular facts to yield a rule, this is construction. Although it's a much more creative process than interpretation, which is just a matter of ascertaining the meaning of words as a matter of historical fact, construction is nevertheless bounded. It must be consistent with the interpretation of the text, and it may not be used to undo the settlement. And although the example of a constitutional construction that I just gave you was a judicial construction, construction is not exclusively a judicial preserve. Every act of legislation is, in a sense, a specification or a construction of the rights articulated in the Constitution. That is, the Government of Canada, when it is introducing legislation in the House of Commons, will have prepared a charter statement ahead of time, which is its thinking through of how it is that this legislation, which is being considered, is consistent with the Charter of Rights. Okay? And that, I'm sure, was done informally before that particular practice was adopted. So constructions can be improved, they can be amended, either in response to a perceived error or in response to new circumstances. That is to say, constructions are a matter of open choice within bounds. They are revisable. It is in this specific sense that it's perfectly acceptable to maintain that the Constitution can be changed. Settlements, however, are not revisable outside of the formal amendment process. Interpretations may be mistaken and can be corrected, but a court may not set aside an existing constitutional settlement and replace it with a settlement it believes the framers ought to have made but did not make. This power may not be assumed legitimately under the mantle of interpretation. Okay. With all of this conceptual work now in the rearview mirror, we're ready to turn to the first of the three doctrinal flashpoints where there is substantial disagreement about how to structure and control the use of moral reasoning in judicial reasoning. We will start with a debate between originalist constitutional interpretation and living tree interpretation. Now, I might surprise some of you given how much I wrote about this as an academic, but I think this particular debate is overblown. Rejecting the fixation thesis, that is, that the semantic meaning of the Constitution is fixed, would be vicious, as I said. And I think the number of judges who actually reject it is a null set. And yet many say that they do. Why is that? I think it rests on a misunderstanding of or inattention to the interpretation-construction distinction. When it comes to questions of interpretation, in the strict sense that I'm using of ascertaining what the bargain was, this is simply a matter of recording the facts. There's no room for courts to improve on it or otherwise change it. Okay? Setting aside or otherwise amending a constitutional settlement is a failure to keep faith with all those who participated in the process of constitution making for the common good, who were assured that the process would bind. And it's not the judicial role to replace the actual constitutional settlement with another provision reflecting some better political or social arrangement. But constitutional construction is on a different footing. Where a political community is faced with changed and unanticipated circumstances, as all communities are continually, the problem arises as to how the new phenomena, be they technological or social, can be addressed under a constitutional settlement that did not anticipate the issue. It's a matter of providing answers to new questions, such as where to allocate jurisdiction, federal or provincial, over aeronautics, nuclear power, cellular data. This is gap filling, things that weren't addressed directly in the constitutional text. And further, where a constitutional provision incorporates a moral principle, as many bills of rights do, judges are required to determine what that moral principle actually requires, and not to defer to what the founders might have believed it required. That is, we're not involved with anticipating or trying to figure out what it is the framers would have done, how they would have applied if they had thought of the issue. The question which confronts everyone who has to work with the Constitution, be it a legislator or a judge, is if faced with a concept like reasonableness, to answer what is reasonable. So the limits to genuine construction are particular to specific constitutional settlements. But there are some limits that can be stated generally. And one such limit is that construction cannot be used to provide new answers to old questions already settled. And much turns here on what is understood by settlement. It is broader, it seems to me, than just what is included in the text. It could also include negatively constitutional proposals that failed and other deliberate omissions. What it does not include is arguments of the type accepted by the Supreme Court of Canada in the Persons case, but rejected by the Privy Council. The counterfactual that had the framers squarely addressed some question, which they did not, they would have resolved it in a particular way. The Constitution does not include provisions that might have achieved unanimous support had anyone thought about them at the time, but that no one proposed, discussed, or voted upon. So there is truth in the claim that the Constitution is not frozen. Where there are modest gaps, generality, vagueness, or irresolvable ambiguity, there is room for judicial construction. That is, of supplementation and development of doctrine. But this claim must be separated from the unsound claim that nothing in the Constitution is beyond the revising pen of the judge. And no serious proponent of the Canadian variant of living constitutionalism advocates such a position. What is settled, and to be sure, we must not understate the difficulty in ascertaining what is settled. Sometimes settlements are deliberately incomplete and the answers sought will not be there. But we must not overstate the difficulty either. There is often a settlement in some respect, even if it's incomplete, and this will sometimes be enough to dispose of a dispute, or at least to foreclose some proffered interpretation or construction. Where such a settlement exists, it is appropriate to call the Constitution to that extent fixed, frozen, encased in amber, whatever you've got. Although the Supreme Court of Canada appears from time to time to insist otherwise, this seems to me to be merely a semantic infelicity that should not be understood as denying the binding nature of constitutional settlements, but allowing rather for the possibility of constitutional construction. Let's move on now to the second arena that I want to discuss, the doctrine of proportionality. This ties back to section 1, which we introduced earlier. I've argued that moral reasoning can be unavoidable where a constitutional provision is drafted using general or vague terms that invite evaluation. And one strategy for dealing with that under determinacy has been to define rights as broadly as possible. Take something like freedom of expression, to divide it absolutely as broadly as possible such that absolutely every conceivable human activity comes under the scope of expression. And then to deal with that by essentially no work being done at the interpretive stage, and proceeding to a second step then of asking whether the limit that's placed on this right by some legislation is justified. Okay. This attitude to interpretation is sometimes said to be entailed by a commitment to purposive interpretation. On its bad days, purposivism prioritizes what are assumed to be the purposes of the Charter. often in line with the commitments of liberal moral philosophy, prioritize that over any serious investigation into whether the text might be defining the right more narrowly. I happen to think that purposive interpretation is incoherent, but let's leave that to one side and focus on this second step, this justification. What are the reasonable limits? Having determined that a right has been limited by a statute, the question that proportionality seeks to answer is the limitation justified? And this is where most, if not all, of the analytical work will be done. The limitations clause in the Charter of Rights and Freedoms, section 1, simply states that the posited rights are guaranteed only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. And this raises some large interpretive questions. Does the text incorporate, as it appears to, the entire political morality of a free and democratic society? And as I mentioned earlier, giving the example of construction, this is not only a question about what constitutes a reasonable limit, but about what the nature of a society is and its relationship with its individual members. What constitutes a society and its common good, and what sorts of restrictions on persons that can be justified by the common good, are large, perennially contested questions of political philosophy. These are not questions that have historically been understood to be questions of law, to be answered by judges. Nevertheless, it does seem to be what judges are required to do. So it's not surprising that a judge confronted with the task of interpreting such a text from a standing start would look for a means to turn it into something a bit more familiar, something more closely related to legal learning, something more technical. And the proportionality test is thought to serve this purpose. Instead of having to dispute contested questions of political philosophy, judges could instead focus on a discrete set of technically worded inquiries. And those inquiries are four. First, does the legislative provision have a sufficiently important purpose? Two, are the means chosen rationally connected to this purpose? Three, are the means chosen minimally impairing of the right in question? Or could there have been some other means chosen that would be less impairing? And four, do the salutary effects of the legislation, that is, the good things it's supposed to provide, outweigh its deleterious effects? These four inquiries are intended to put a judge in a position of answering whether the limit on the right is justified. And in many cases, probably most cases dealing with Section 1, that inquiry is resolved using the criterion of minimal impairment, rather than the more controversial and more openly moral balancing of the fourth step. So the question is, if the objectives of the impugned legislation could have been achieved more efficiently, that is, with more or less the same results, achieved by some less restrictive means, then the litigation can be disposed of without having to delve into the even more wide-ranging evaluation of the legislative purpose required by balancing. But the point shouldn't be overstated. Even minimal impairment inquiries cannot do away entirely with the evaluation. The criteria for establishing whether other potential statutory means will allow for a legislative proposal's purposes to be achieved sufficiently, or whether a limitation on a right can be considered to be minimal, will be in part moral criteria. Likewise, the first question of the importance of the legislation is it sufficiently important? Itself, it's not a question that can be answered empirically or through the ordinary techniques of legal reasoning. So proportionality analysis presents the judge who's aiming at virtuous interpretation with two stumbling blocks. The first, which I've already mentioned, is to turn from interpretation prematurely, when there's still fruitful work to be done, and proceed to the justification stage. The second stumbling block is to mistranslate moral questions into technical questions. Proportionality reasoning cannot proceed without moral evaluation. This is most obviously the case when balancing the value of achieving a legislative goal against the loss experienced by persons who are denied some liberty or benefit that they claim as a matter of right. But moral evaluation is also significant to the other stages of the analysis as well, and often in ways that go unnoticed. Particularly when assessing minimal impairment, technical evaluations and factual assessments are required. For example, The question of whether a requirement that cigarette manufacturers provide health warnings that are attributed to a government agency, whether those will be equally effective to a requirement that cigarette manufacturers provide unattributed health warnings, is a factual and technical question. This was actually a big deal back in the 90s. If you've got on the cigarette package a warning that says Health Canada says that smoking is harmful, is that going to be as powerful as requiring the manufacturers themselves to say, this product is very, very bad for you? Okay? We believe it's bad. Okay? So determining whether one of those is going to be more effective than the other in convincing people not to take up smoking is a technical question. But determining what constitutes adequate or substantial fulfillment of a governmental objective, okay, is it a 10% reduction in smoking, 50% reduction, achieving a completely smoke-free society? Or whether the political community ought to be willing to accept a 20% reduction instead of a 50% reduction in exchange for less burdensome legislation. That's not a technical or factual matter. Moral evaluation is also required in ascertaining the purpose of legislation and assessing whether the purpose is sufficiently important to justify the limitation of a right. And ascertaining legislative purpose is a matter of moral evaluation because it's a matter of both describing and interpreting a social institution, legislation. And the point's easy to overlook because usually little analytical work is done at this stage. The proper purpose inquiry typically presents a low hurdle, and very few cases are decided on the basis that the purpose of the impugned legislation is constitutionally infirm. After all, legislatures don't tend to waste their time. They're not going to enact legislation on something that isn't going to be objectively important. However, to fully appreciate the nature of this stage of proportionality reasoning, one has to attend not only to those rare cases in which courts conclude that a statute does not have a proper purpose, but to the many cases in which courts decide that it does. Of greater significance than the straightforward judicial statements evaluating the purpose of a statute are the characterizations of that purpose. Significant evaluations of legislative purposes sometimes occur off stage, in that legislative purposes are either perceived and dismissed out of hand without comment, or simply don't cross the judge's field of vision. Okay? So proportionality analysis affords multiple points of entry for practical reasoning. And the most analytically significant moments of practical reasoning in proportionality analysis will not necessarily occur at the balancing stage. How the legislative purpose is characterized may be far more significant, feeding not only the overall balancing analysis, but also the assessment of the importance of legislative purpose, and crucially, the assessment of necessity or minimal impairment. Okay, let's recap. I've argued that moral reasoning is largely unavoidable in constitutional interpretation, and the best that we can hope for is a commitment to the fixation thesis and a genuine effort at interpretation that can discipline and temper judicial idiosyncrasy. Proportionality analysis is an attempt to structure and direct judicial reasoning, but in practice, it has a tendency to misdescribe moral questions as technical questions, keeping moral reasoning off stage where it's unarticulated and undefended. There is one last juridical concept I want to quickly canvass with you, and it is the oft-derided concept of charter values. Charter values is often employed wherever you might expect to see a moral question embedded in a legal question. It is an appeal to morality that is thought to be a product of the charter and therefore uncontroversial. It's a matter of the constitutional settlement. To explain the concept, I'm going to quote a few paragraphs from a case called McKitty and Hayani. It's a 2018 judgment from my court that addressed the meaning of death, something that more than a few of you might be contemplating at this point in the lecture. In any event, what I said there was, in litigation between private parties, it's open to a party to argue that an applicable common law principle or rule is inadequate in some respect and ought to be changed. In deciding whether it would be appropriate to modify the common law, courts must consider the reasons for the proposed change. To identify relevant considerations and to minimize judicial subjectivity, courts have sometimes sought guidance from principles that motivated the enactment of particular provisions of constitutional texts, including the Charter. The various moral norms, principles, and aspects of well-being associated with particular provisions of the Charter are sometimes referred to as Charter values. Charter values are not Charter rights by another name or in a different setting. They are a different juridical concept. They are essentially a catalog of some of the human goods that judges can use in legal reasoning. Recent decisions from the Supreme Court and this court have scrutinized the use of Charter values. There is a concern that although the concept of Charter values is intended to reduce judicial subjectivity in moral reasoning, the selection of Charter values and their prioritization are both unavoidably idiosyncratic. Charter values, unlike Charter rights, are not taken from a canonical text. There's no methodology to guide the degree of abstraction at which they're formulated, or to resolve claims of priority when they conflict. Their formulation and use in judicial reasoning should therefore be approached with careful attention to the rules that govern their use in different contexts. Now, the same note of caution was expressed by my colleague Justice Lowers and I, writing jointly in another case called Gale in Canada, in a passage that was later quoted with approval by Justice Rowe in the Trinity Western case at the Supreme Court of Canada. There we said, Charter values lend themselves to subjective application because there's no doctrinal structure to guide their identification or application. Their use injects a measure of indeterminacy into judicial reasoning because of the irremediably subjective and value-laden nature of selecting some Charter values from among others, and of assigning relative priority among Charter values and competing constitutional and common law principles. Okay, so these problems, I think, with Charter values are fairly obvious. There's many principles, values, and norms that find expression in the Charter of Rights and in other constitutional texts. The category of Charter values is therefore extremely broad, including goods derived more or less immediately from the enumerated rights and freedoms, like freedom of expression or equality under Section 15, but also from Section 1's principles of a free and democratic society, and entailments from even more abstract principles such as human dignity. The lawyer who is advancing a Charter value as controlling the outcome of a legal question needs to be able to explain, why am I advancing this particular value? Why am I saying that this is important? Why should it take priority over all of the others when there's a conflict? And what are the reasonable limits of a free and democratic society? After all, Charter rights don't present themselves as absolute, but subject to qualification. But these sorts of questions are never presented to courts, and all we're left with is because Charter values. So the technique of appealing to Charter values is, at the end, little more than a rhetorical device. And judges who accept appeals to Charter values are not taking guidance from some past lawmaking act or from some community consensus on a useful and directive principle. All appeals to Charter values do is to provide a mechanism to hide from view, and so from scrutiny, the very thing they're meant to replace: the imposition of subjective and potentially idiosyncratic applications of moral judgment. Well, it's time to conclude. Moral reasoning, it seems to me, in judicial reasoning, is largely inescapable. There are techniques and doctrines intended to narrow the scope of judicial discretion, but a residual element of moral reasoning will always remain. For judges, deference to the moral judgments of Parliament expressed through legislation will sometimes be an answer. When we're outside of our largely technical domain of expertise, and when we are addressing questions that we lack the institutional resources to fully resolve, we will have reason to defer to the reasonable judgments of Parliament. But the reasonableness of a judgment is never simply the fact that it's the consensus view of some important social group, or it is what the community happens to believe. When faced with significant moral questions, we have to proceed on the basis that there is some truth to the matter, and reason in the first person as to what that truth is. Returning to the McKitty decision, which addressed the adjudication of the common law definition of death, I concluded that the court could not simply defer to what the medical community believed about death. I said, in that case, the determination of legal death is not simply or even primarily a medical or biological question. The question of who the law recognizes as a human being, entitled to all of the benefits and protections of the law, cannot be answered by medical knowledge alone. Facts about the physiology of the brain-dead patient are needed to determine what obligations are owed to the brain-dead patient, but the inquiry is not ultimately technical or scientific. It is evaluative. Who the common law ought to regard as a human being, a bearer of legal rights, is inescapably a question of justice, informed but not ultimately determined by current medical practices, bioethics, moral philosophy, and other disciplines. And all of that is to say that although the technical questions of law can often be answered without resort to more than a background understanding of the persons and human goods that law is meant to serve, there will be times when something more is required. And when those times come, virtuous interpretation will require that judges be fully transparent and not mistranslate moral questions into technical questions, and thus deflecting attention and reducing accountability. It will also require a measure of humility, born of a recognition that judges have no better claim to expertise in moral reasoning than anyone else. Thank you.